All right, I think we're up and going here. So let me just first introduce a bit about who we are, me and my firm. Like I said, I come from a long line of estate planning attorneys. My father is an estate planning attorney too. He's now retired, and we're Arizona natives, born and raised in Arizona. And I actually was his legal assistant as a kid, and so I was the one in the back room typing up the living trust, and so I got exposed to it at a very young age. And my dad was a solo practitioner for most of his life. And like I said, he's now retired. I eventually went to law school myself and followed in dad's footsteps. So I've been doing it for about 21 years now. And the firm has grown a bit over the years. We are now a firm of three attorneys, and we have a wonderful team around us. And so you see this picture here. This is myself, and then the two attorneys there. That's my partner on my right, Jeff LaClair. He's the other bald guy. We both lost our hair thanks to probably our careers. And then behind us is Ryan Downs, who's a great attorney too. We've been a team here for many years. Jeff is my partner. We've been together for many years, and so we do just estate planning. That's really our focus. We've been doing it for over 40 years now. And we focus exclusively on estate planning and trust administration, which means we don't get into other areas of law, right? We don't do litigation, we don't do bankruptcy, we don't do divorce. We just focus on what we're best at, estate planning, because it is a constantly changing area of law. We want to keep up to date, and we think the best way to do that is to focus solely on estate planning. And we do all aspects of estate planning. So we don't just design trusts, but we also see them throughout the lifetime of the client and beyond. And when the client passes away, which of course many of our clients have because we've been doing this for 40 years, we get to see these wills and these trusts work in real life. And that's important because that's when the documents are really put to the test, right? And at that time, we can see what works and what doesn't work in real life. And that's very helpful to work with an estate planner, I think, who's seen things from beginning to end many times. And all of us, we have degrees in accounting and tax law, and that's important because estate taxes and estate planning, they all go hand in hand. We've got to make sure you're not paying more to Uncle Sam than you should. And so all of us have a background in accounting or tax law. And we have offices located throughout the valley, in Scottsdale, in Chandler, Tempe, Glendale, wherever you might be coming from, probably from Scottsdale. We should be close by. Our office is there at Scottsdale Road and Indian Bend. This is where our Scottsdale office is. So that's just a little bit about us. So if you could, again, have your outline handy. I'm pretty good at following the outline, and that's going to help you follow along in the presentation. There's some blanks on the outline to fill in, to remind you of what we talked about. I know it's going to be a lot of information, kind of a fire hose at you, but the outline will be a good refresher for you. If you need to go home and share it with your spouse or whoever, it'll be good to have that outline in front of you. And so I hope you can just relax and enjoy the time. And maybe I'll start out, actually, just this morning, my dad sent me a joke that I thought that maybe was appropriate for today's seminar. This is from one lawyer to another, right? My dad sent it to me. I thought this was just a fun way to start out. He said, my friend, we'll call him Lee, was a single guy living at home with his father and working in the family business. He knew that he would inherit a fortune once his father died. So Lee wanted two things. He wanted to learn how to invest his fortune, and he also wanted to find a wife to share his fortune with. But one evening at an investment meeting, he spotted the most beautiful woman he had ever seen. Her natural beauty just took his breath away. He says, and then he goes up to her and he says, I may look like just an ordinary man, he said to her, but in just a few years, my father will die and I'll inherit over $200 million. Well, the woman was very impressed and she took his business card. 2 weeks later, she became his stepmother. All right. So Lee learned very quickly that women are actually better at estate planning than our men. A fictitious scenario, of course, that actually things like that happen. That's why we do estate planning, because you never know what the future holds, and we want to make sure we protect the estate to make sure it goes to the people that you want it to go to. So let's get into what estate planning is. And estate planning, let me just define it for what it is first. Estate planning, it's really answering two questions. Okay, the first one is, if something happens to you, then who's in charge? Right? So if you're disabled or if you pass away, who's going to be in charge of your affairs? The second question we want to answer is when you do pass away, who gets your stuff? And so that's really what we're talking about today. Who's in charge and who gets your stuff? And you think that'd be very simple to answer those questions, but whenever lawyers and judges and legislators get involved, things get very sticky very quickly. Now in Arizona, we have a number of different types of laws that we look to answer those two questions. The first one would be what's called the Arizona Probate Code. All right, this is just a mock-up here. The probate code is actually bigger than this book here. The probate code is a large body of laws in Arizona that says who's in charge and who gets your stuff when you pass away. And so that's one thing that we want to look to, but note that estate planning is a state issue. And so it's governed by the state where you are a resident. That's where you should do your estate planning, is the state where you reside. But also, if you have property in another state, maybe you have a vacation home in Colorado. Well, that means Colorado law would apply as to that property, at least under the probate code, if we have to default to the rules. So you could have many different sets of laws applying. Also, if you have certain types of assets, such as a 401k or tax-deferred retirement plans, those are governed by federal law, not by state law. And there's a body of law called ERISA. Okay, ERISA stands for Every Ridiculous Idea Since Adam. Okay, it's a large body of laws, again, federal laws, tax laws, and other laws that, as to your 401ks and other types of assets, say who's in charge and who gets your stuff. And so it can get very confusing very quickly. Now, my question for you would be, would you prefer to bypass all of the rule books and decide for yourself who's in charge and who gets your stuff? But I think you would. And hopefully, if I could see you, you'd be raising your hand right now and say, yeah, I don't want a legislator to decide for me. I don't want a judge to decide for me. I want to make my own decision, right? As to who's in charge of my affairs and who gets my stuff when I die. And you have that right. You have the right to make your own decision. And that's what estate planning is. When you plan ahead through an appropriate estate plan, we can bypass the rule books, and then you get to decide those things instead of leaving it up to the state. So let me ask you a question here. Okay, I'm going to send you a poll. All right, you should see it there. What percentage of Arizona adults have a will in place? Most of you chose A or C. And so 48% or 27%, which you think would be a logical guess. There was one person who chose 100%. If you're at my live seminar, I actually would give you a $50 bill, but I can't, unfortunately, because you're not here. 100% is actually the right answer. It's a bit of a trick question. I'm a lawyer, I can't resist, right? But actually, everybody in Arizona has a will. When you came out of your mother's womb, you actually had a will already. The question is who wrote it for you, because your will, all right, if you haven't done your own will, it's actually in this probate code right here. The state of Arizona has already drafted a will for you. The problem is it doesn't say what you say. So that's my hope, is after today, you will be motivated to write your own will so we don't have to have the state write it for you. And so let's talk about how to do that and what's the best way to do that. All right, let's go to mistake number 7. Okay, one of the top mistakes when it comes to estate planning is letting your family go to, you might have a guess here, the probate court. All right, you probably have heard of probate, right? Probate is definitely something we want to avoid. It's probably the #1 mistake. And I like to talk about mistakes, how to avoid mistakes when it comes to estate planning. Just because I'd rather you learn from other people's mistakes instead of making your own. And so it's kind of the best way, I think, to approach this subject. So probate court is really, it's the court process after you pass away of distributing your assets and deciding who's going to be in charge of that. And it's a very public process. So we have probate on 2 areas of life. Okay, the first one, again, is after you pass away, we have death probate. But also, okay, during your lifetime, we might have probate as well. We call that conservatorship or living probate. And so that means you're disabled, but you can't sign your checks. You can't pay your bills. You can't run your business or whatever you do every day. You can't do it because you're disabled. And so probate can kick in both after death and during your lifetime. It's a very public process. We want to avoid it. It's very expensive. It is public. We have to file your will to the court. We have to publish notice in the newspaper that you passed away. We have to give creditors and long lost relatives a chance to make a claim against your estate when you're not here to defend it. And so it's a very burdensome process on your family at a time that's already very traumatic, right? During a death or disability, there's enough stress on the family without having to get dragged into court for 2 years. And that's very expensive to have an attorney on retainer for 2 years. So we want to avoid it. Now, here's what I want you to remember here in Arizona, that where there's a will, there's probate. A will does not avoid probate in Arizona. It's better than nothing. At least with the will, you've told the judge who's in charge and who gets your stuff. That's laid out in your will, but it still has to go through the probate process. So for that reason, I don't do very many simple wills anymore because, yeah, again, it's better than nothing, but it's still going to have to require probate. And the probate limit in Arizona is $75,000. So if you have more than $75,000 of assets or more than $100,000 in equity in real estate, then that's enough to put you into the probate court system upon your death or disability. So it doesn't take much before you're going to be there. So now there are some probate alternatives, okay? We don't have to go through probate. Let's talk about how to avoid it, okay? One way to do that would be simply through joint tenancy. The joint tenancy means that you have a joint owner on the title to your assets. And you may already have this. If you're married, maybe the deed for your house says, husband and wife with right of survivorship. And if it has that language on the deed with right of survivorship, then that means when the first spouse dies, the second one can automatically receive the house without going through probate. Same thing with bank accounts and vehicles. If you have a joint owner, then it should pass to the surviving owner when the first one dies. So that gets you halfway there, at least. But eventually the second spouse will die, and then we're going to be in probate for the children. Now you might ask, well, what if I just add my children to my bank accounts and to the title to my house? Will that avoid probate? Actually, it will. You can add as many people as you want to your titles. But the other question, more important question, is that a good idea? And I'd say, no, it's not a good idea to add anybody to your titles other than, I would say, your spouse, because that's a very dangerous thing, right? Because you don't know what's going to happen in the life of the person who you added to the title. So if you add your daughter to your bank account, for example, what happens if she's in a divorce? Well, now your bank account's part of her divorce proceeding. And what if you add your son to the title to your house? And then he gets sued. He's in a car accident. Well, now you're going to lose your house in the lawsuit. So don't add anybody to your titles. It's just too dangerous. I could tell you lots of horror stories of situations. In fact, I had a mom who put her daughter on her bank account over at Bank of America. She just wanted her daughter to be able to sign checks, right? It sounds reasonable. Well, the daughter also had a mortgage at Bank of America, and she defaulted on the mortgage. So guess where the bank went to get the money to pay off the mortgage? Well, they went to mom's account, and they could do it because the daughter was a joint owner on the account. So we don't do that because we don't want to expose your assets to their problems. There's better ways. It also causes all sorts of tax issues and liability and things that we won't get into, but just know, unless it's a spouse, I don't recommend adding a child or anybody else to your bank accounts and other assets. Unless maybe it's just a very small account, you want them to have quick access to it. Just know that you are having some potential exposure there. A better way would be what's called beneficiary designations. Naming a beneficiary is different than joint tenancy because when you name a beneficiary, they don't get it until you pass away. So it's still yours during your lifetime. And then when you die, it becomes theirs. So you haven't exposed it to their problems because it's still your asset during your lifetime. And so you can do this with most every type of asset in Arizona. You can name beneficiaries of your life insurance, of your 401ks, your investment accounts, even your bank accounts. You can do what's called a POD, payable on death. You have to go to the bank and fill out their form. And just keep in mind that you have to go and deal with each asset separately. So you have to go deal with the company that has the asset, fill out their form, and name the proper beneficiaries. And so long as it's done right and they keep the form on file, then there should be no trouble as far as probate when you pass away. It'll just pass directly to the beneficiary outside of court. Now, there are some pitfalls with this as well, though, that you should be wary of. One is when you name a beneficiary, you have not done any disability planning, right? Because when does the beneficiary get the asset? It's not until you pass away, right? So if you're still living but disabled, they cannot access that bank account to pay your bills. So that could be a problem. Also, when you name beneficiaries, there's nobody in charge. Let me give you an example. In Arizona, we can do what's called a beneficiary deed. You can record a deed saying who gets my house when I die. And we do this oftentimes. In fact, one time I helped a mom name her 3 kids as a beneficiary of her house. We recorded the deed and everything was done correctly. When mom passed away, who owns the house now? Well, it's all 3 kids, right? Well, that means that if they want to sell the house, then who needs to agree to it? Again, all 3 kids do. Okay, can you see the potential problem there? By naming all 3 of them as beneficiaries of the house to keep things equal, the problem is they ought to be on the same page. And in this case, they weren't. 2 of them wanted to sell it, 1 of them didn't. Well, that house can be sitting around for years until they all get on the same page because nobody's in charge just by naming a beneficiary. And also, when you name beneficiaries, you have no control over when the money goes to them, right? So if for example, I've got a life insurance policy and I've got a couple of teenage boys. Do you think it would be good to name them as beneficiary of my life insurance? Well, I might think, well, that's good because it avoids probate. But the problem is if I get hit by a bus tomorrow, then my boys would inherit a bunch of money all at once. And that'd be a terrible thing for teenage boys to get cash, right? Or the best case, the money would stay in court, tied up in court for them until they're 18. And then they get a very nice birthday present at age 18. That will ruin them. And so we don't want to name young beneficiaries or irresponsible beneficiaries as on any of your assets because you can't control what happens to that money when you die. So those are some things to look out for. Now, the best way to avoid probate here in Arizona is the revocable living trust. And I really want to hone in on the revocable living trust. This is our bread and butter. We have done thousands and thousands of these trusts over the years, and we have seen many of them. Again, I don't know how many hundreds or thousands of clients we've had pass away over the years, but we've seen these trusts work time and time again. And so let me talk to you about what a trust is, because there are different types of trusts and why we like it. So this particular trust is called a revocable living trust. And every trust has one thing in common. Okay, it has 3 parties that come together to form the trust agreement. So the first party to the trust is you as the trustor. All right, the trustor is the creator of the trust. And if you're married, that's both husband and wife together. Typically, we just do one joint trust for husband and wife. We don't usually have to do separate trusts here in Arizona because we're a community property state. So you are the trustor of the trust. You are also the trustee of the trust. Okay, the trustee is the one who controls the assets that are in the trust. So let's say that I create a trust and then I put my house in the trust. Well, that means that the trustee is the one who can sell the house. Or if I put my bank accounts in the trustee is the one who has the right to sign checks. Okay, so the trustee controls the purse strings. And so now, who do you think we want to be the trustee during your lifetime? Well, we actually want the trustee to be you. Okay, the trustee is going to be the person that we want to be in control, and that would be you. And that's the nice thing about a revocable living trust is that we can name you as the trustee so that during your lifetime, you have full control. Nobody else has control over this trust during your lifetime. Now, eventually, we're going to need somebody else to step in your shoes, right? Because of either death or disability. And that person is called the successor trustee. And the successor trustee is the one who steps in your shoes. That might be a child. It might be a good friend. Maybe it's a CPA or a corporate trustee. All right, we can always find somebody who's going to be that right fit for your family to step in your shoes, both during your disability and after your death, to manage the assets according to your instructions. And that's the key, is the successor trustee can't go off and do their own thing. They have to follow the instructions that you've laid out for them in the trust. Now, the third party to the trust is the beneficiary. And the beneficiary is the one who gets to spend the money. So we like that position. We also like you to be the beneficiary, right? Because I assume you still want to spend your own money after you create this trust. And you can because you are the beneficiary. So do you see a pattern here? You are the trustor, you are the trustee, and you are the beneficiary. And that just means you have 100% control. Nothing really changes during your lifetime other than the titles to the assets. And we'll talk about that. And so that's one reason why I really like a revocable living trust, unlike an irrevocable trust, where you have to name a third party as the trustee. Here you don't. You get to have full control. You can change it whenever you want to change it. It is revocable. That just means you can change it. And that's good because your life will change over the years. So it's just sitting on the shelf waiting for your death or disability to happen. And then it springs into life without involving a court. So it's really my go-to vehicle for estate planning. Now that you know what a living trust is, let's go to mistake number 6. Okay, mistake number 6 is thinking that all living trusts are the same. All right. Now you probably have heard of living trusts. Maybe you've even seen, advertisements on the internet for them. Where you can do your own trust and things like that. And yeah, the truth is you could just go get a fill in the blank form. You can go buy one at Staples or go to a credit union and have a document preparer do one for you. You can print one off the internet, but I got to tell you, all trusts are not the same. Okay, just because you have a trust doesn't mean you're good to go. I like to use the example of vehicles. All right, probably nobody here is driving a Yugo anymore. There's no more left on the road. The Yugo, okay, was called the Mona Lisa of all bad cars by Time magazine. And they said the best thing about the Yugo was it had a rear window defroster. So when you had to get out to push it, your hand stayed warm. Okay. They said that was the best thing about the Yugo. But let's compare that to the Mercedes or to a wheel-built Chevy truck or whatever it is that you like driving. They're just not going to be the same. Just because it has 4 wheels and an engine doesn't make one car the same as the next car. And that's true with living trusts as well. Now, with a car, you know pretty quick whether or not you got a lemon because you'll be on the side of the road waiting for a tow truck, right? But what about a living trust? When do you know whether you got a lemon for a living trust? Well, not until it's too late because either you're disabled or you pass away. That's when the trust goes into action. And by then, it's too late to fix it because you're the only person who can fix or change your trust. Your kids can't do it for you after the fact. So you have to have it done right before the event happens. Otherwise, we're going to be stuck in court in a real nightmare. So just keep in mind that they are not all the same. And let me give you one example of how they're not all the same. Okay. The number one reason, again, that people do live in trust is to avoid probate. But will your trust really avoid probate? I can't tell you how many trusts I've seen that had to go through probate. And that's unfortunate because that means something got missed. And what happened is they did not transfer their assets into the trust. And that's a very important stage of creating the trust. First, we design it, and then you sign it. Okay. Now, once you sign the trust, you have an empty bucket, and we got to go fill it up with all of your assets. We've got to put your assets into the trust, get them out of your name into the trust name. And if we don't do that, then the assets are still in your name when you die, which means they have to go through probate. But if they're in the trust name, they don't go through probate because the trust doesn't die. So it's very important to go through this stage, and we have to do a new deed for your house to get your house in the trust. We got to maybe do new titles for your vehicle. We got to submit beneficiary forms for your accounts and retitle accounts and things like that to get everything pointed into the trust. And that's very important. And it's, at our firm anyway, we would help you with that. I don't want to overwhelm you thinking it's a nightmare. It's not if you have the right help. Okay. Again, this is something we do every day. And so we would help you through the process. And it's not that bad. And then once it's done, and then the nice thing is that it's going forward, maybe you buy a new car or you have a new bank account. You don't have to come back and see your attorney when you get new assets. You just got to make sure that you buy the asset in the name of the trust. And so usually what we do is you have like an ID card that you carry around with you. It has your trust information on it. And then you just show that to the dealership when you buy a car, or you show it to the bank when you open an account. So they will issue the title in the name of the trust at the very outset. And then you just know whenever you buy an asset, it's in the trust from the very beginning. And it's also important to keep it up to date. I would recommend anybody, if you have a trust and it's been a few years since you had an attorney look at it, be sure and do that, because it's very easy for these things to slip through the cracks. And so we have our clients come in every 3 years is what we do. And we just do just a free review for them every 3 years so they can make sure that the assets are in the trust like they should be. We can help them catch things that got overlooked. So that's really, I'd say, the number one reason, why I'd stay away from the internet and do-it-yourself forms. Not only is the language not what you want it to be typically, but beyond that, those trusts just never get funded, right? The assets never make it into the trust because you don't maybe know how to do it, and so that's just really important to get it funded so it doesn't end up in court. Whatever you think you're saving by doing an internet form, you're going to pay many times that on the back end when you have to go through probate and the trust isn't done properly. All right, let's go to mistake number 5. Mistake number 5 is failing to address what will happen if you're disabled. So disability is something that we need to talk about. It's no fun. We don't want to think about what happens if I'm incapacitated, but you do want to be ready for that possibility. And I would say there's really 4 documents that you want to have in place to be prepared for a disability situation. The first one would be the revocable living trust, all right? Because the nice thing about the living trust, unlike a will, it kicks in as soon as you pass away. I'm sorry, it kicks in even before you pass away. And so if you're disabled, then the successor trustee can step in for you and sign your checks and pay your bills. And so that's real nice to have that trust in place right away, and we're good to go. The other thing that you would want has to do with your medical decisions. It's called a medical power of attorney. And the medical power of attorney is where you appoint an agent to make medical decisions for you if you ever can't do it yourself. And along with that, you would do a living will, which is the instructions for them so that they know what your desires are as far as withholding life support. We've all heard of horror stories, right? When somebody in the family doesn't have a living will, and then the family is having to fight over whether, to put them on life support or not. You want to make sure that is spelled out very clearly in your medical power of attorney and your living will. You also want to have what's called a HIPAA authorization, number 3 there. That's what authorizes your loved ones to speak with your doctors. If you don't have that done in advance, then the doctors can't speak to your family, and that's not good. And then finally, number 4 is a durable general power of attorney. It's just a financial power of attorney. I use it as a backup to the trust. And the power of attorney is going to be the same person who's the successor trustee of your trust, typically. And so that gives them authority to sign on your behalf on any of your financial type investments or anything financial. And so it's a backup to the trust. They don't always work. And then when you pass away, they're void. They don't work when you die. But it is a good safety blanket to have in addition to the trust, just in case you had an asset that maybe wasn't in the trust and you were incapacitated, your power of attorney could deal with that asset. So if you have those 4 things in place, you're going to be in good shape when it comes to disability from a legal standpoint. Your living trust, your medical power of attorney, your HIPAA authorization, and your financial power of attorney. All right, well, let's go to mistake number 4. Okay, mistake number 4 is something that is so different for every family. And I just at least want to put some thoughts out there for you to think of. Not protecting your beneficiaries from themselves. Okay, think about this. Okay, when you pass away, your money is going to go to your loved ones. And my question for you would be, are they ready for that? Is that going to be a blessing or is it going to be a curse? And I say that an inheritance can be like a brick. Okay, I've got this brick in my hand. I can use it to bash in a window, or I can use it to build an orphanage, right? It just depends on whose hands is it in. If it's in the hands of a good person, it's going to be a blessing to somebody, to that orphanage. But if it's in the hands of an irresponsible person, it can be very dangerous. And inheritance is the same way. So who are you passing your money on to, and are they ready for it? Just know in the trust, we can tailor the trust to your circumstances or to your beneficiary's circumstances. And everybody's different here. Maybe you have young children or grandchildren that you want to give money to. Well, the worst thing you can do is just give them a bunch of money right when you die. we want to spread it out, right? And give it to them maybe over 10 years, or maybe when they hit a certain age. Whatever it is, we can do it in the trust. Maybe you have beneficiaries that are adults, but they're just not very good at managing money. I get that all the time from clients. They say, oh, my kid doesn't know how to save. He's just going to spend it within a year. Well, we can take care of that in the trust. We can put in some barriers, and we can just sprinkle that out to them over time, or we can have a third party manage the money for them. There's a lot we can do there to protect the money so it goes to good purposes. And again, I could spell out all sorts of particular circumstances, special needs children, beneficiaries that have creditors or lawsuits, things like that. Just know that there's really nothing we can't do in the trust to customize it to fit your particular circumstances so the money goes to the right people at the right time. That's really what I want. I don't want the money just to go to them all at once if they're not ready for it. It should go to the right people at the right time. All right, let's go to the next mistake here. I'm hoping after going through all those potential problems that could exist in a family, maybe you're saying, but James, I only have grade A beneficiaries. All right, my kids, they're all superstars. They all know how to manage money. I just want to give it to them and then let them worry about it. And that's great. If you're saying that, then wonderful. And maybe that's true. But the question I would ask you is, well, what about people that might come into their life? Okay, maybe your child is responsible and they're very good with money. But what about his or her spouse? What about, do they have any creditors that might come around the corner? What about Uncle Sam as a tax creditor? What I don't want to see is that when you pass away, the money goes to your child, and then somebody comes in and grabs it from your child, somebody who you didn't want to get it. I call them unintended beneficiaries, right? Beneficiaries who get the money, but you didn't want it to. You didn't want them to. And so that's mistake number 3, is not protecting your beneficiaries from unknown third parties. And these can come in all shapes and sizes. I would say the number 1 would be an ex-spouse of a child. All right, we love our in-laws so long as they're married to our kids, but if they're not married to our children at some point, we probably don't want them to receive the family inheritance. And that happens all the time, especially in Arizona, because we're a community property state. And so that means the presumption is every dollar is owned half by husband and half by wife. And now an inheritance is actually an exception. It's not community property. When I inherit money from somebody, it belongs to me, not to my spouse, because it's separate property. But then the problem is, what do your kids do with the money once they receive the inheritance? Well, they're probably going to, maybe they buy a house or they pay off the mortgage and their spouse is on the title. Maybe they put the money in a joint bank account. Maybe they put the kids through school. By doing any of these things, what they're doing is they are commingling the money and they're turning it into community property. And that's a shame, because what happens is the property was separate when they inherited it. Then they commingled it and it becomes community property. And then let's say 5 years after you die, there's a divorce. Now the money's going to go half to the ex-spouse, and that's probably not what you want. So that's just one example. But I would say other examples would be creditors. They would be, again, Uncle Sam can be a potential creditor. Lawsuits. What if your child gets sued from a business or from a car accident? I see that happen all the time, where a child gets sued, and then the lawsuit goes against them, and then they just go grab the money that they inherited. The money is gone. So what causes these problems is outright distributions. And this is what probably 95% of the trusts I see do. They have outright distributions, which just means when the money, when the parent passes away, the money goes outright to the child, usually at a certain age. Maybe that's age 35, for example. All right, and then once the money leaves the trust, we can't protect it anymore. So my recommendation is always avoid outright distributions, because that's what causes the problems. Even when the beneficiaries can handle their own money, it's still a bad idea, because another person might come into their life and take it from them. So what we do instead is we do what's called a protective inheritance trust. And this is something that we started doing, probably 8 years ago. And we've seen these work many times, and it's a wonderful tool. And it's unique. I don't see this done very often. I think most trusts I see from are probably about 95% of them are still outright distribution trusts. But the PIT, the Protective Inheritance Trust, is a better way to go. And so what the PIT is, I'm going to call it the PIT, meaning Protective Inheritance Trust. It's like a sub-trust gets created when you pass away. So let's say you and your husband, you create the trust, and then you die, and you got 3 kids. Well, when you pass away, your trust gets divided into 3 sub-trusts, one for each of your kids. And those sub-trusts, I call them PITs, okay, the Protective Inheritance Trust. The nice thing about them is it allows your child to be the trustee, but nobody can take the money from them because the money got locked away into this separate protective trust for them. But because they are the trustee, they can decide how to invest it. They can even decide when they want to pull money out. There's no restrictions on them unless you want there to be restrictions. But it's as if it was their own money. They have full control. But so long as they keep it in there, and it's protected from the spouse, from the creditors and the lawsuit and all those things. It's a wonderful tool. Let me quickly just give you a little case study of what this might look like. All right, let's say you've got this son, Bob. Okay, Bob's a great kid. He's an orthopedic surgeon. You say, well, I just want to give him the money. And we could just give him the money when you die, but better, let's put it in the PIT for him. You see the protective trust there. The money goes from your trust into the protective trust for him. Under the terms of the trust that you did. Now, Bob's a good kid, but maybe he's got a high maintenance spouse, or maybe he's an orthopedic surgeon. What happens to surgeons eventually? They get sued, right? It's only a matter of time. Do you want your money to get to pay off his lawsuit? Certainly not. Well, if the money is in the PIT for him, then Bob can control it, and he can share the money with his wife if he wants to, but he can just pull out a little bit at a time. She doesn't have access to the whole enchilada all at once, right? And when he gets sued, they can't touch the money that's in his protective trust. So his inheritance has this protective wrapper around it that you gave it to him. Bob's going to love you for that. Now, maybe you got Jane. Okay, she's a sweetheart. We love her. But she's married to this guy named Dennis the Menace. Okay, and Dennis the Menace is always hitting her up for money. He's always investing in it in these crazy schemes. So you just know the money is going to get blown. Well, instead, you can put the money into a PIT for Jane. And maybe Jane can be the trustee, or you can even have somebody else be a co-trustee with her. And that way the money will be protected. And then when there's a divorce, eventually down the road, Dennis the Menace, he doesn't get a dime of the money from Jane. It's like a built-in prenup for her, which is real nice. And then finally, we got Jim. Jim he's every family's got that kid, right? He's the one. He's just irresponsible. He can't save 2 dimes if his life, was depending on it. So with him, you're going to create this PIT for him and put the money in there for sure. But you're not going to make him the trustee. You're going to have maybe Bob be the trustee over Jim's trust, or somebody else. That way, the trustee can dish out money to Jim as he's ready for it. And that way his creditors don't get it. And that way he doesn't just go blow the money and buy himself a new Ferrari, right? So the money will be used for good purposes for Jim. So, I mean, regardless of who you have in your family, whether you have all Bobs or you got a mixture of Bob and Jim and Jane in your family, all 3 of them are better off with the protective inheritance trust. So my view is, why not just do it in every trust? And so that's our approach, is every trust we do will have a protective inheritance trust for each of your beneficiaries. That way we can be assured and have the peace of mind of knowing that this money is going to go to the person that you want it to and not be taken away from them by an ex-spouse or a creditor or somebody like that. So this is a big deal. Our clients and their children who inherit the money have loved this feature of the trust. All right, let me, as we're getting close to winding down here, let me throw out another poll question for you. Make sure you're still awake out there. All right, because I've talked about lawsuits and how the trust, if we do it right with the PIT, it can protect your beneficiaries from lawsuits, right? What about protecting you from lawsuits? Okay, it can protect your beneficiaries from lawsuits if we do it right. But does it protect you from lawsuits? Okay, so say it protects you from lawsuits during your lifetime, true or false? And I always get mixed responses on this. And this is something that we always like to make very clear when clients come in to do a trust. So about 42% of you said it's true that it does protect you from lawsuits, and 58% said false. And that's been about my experience. About half and half people have different responses to this. And actually the answer is it's false. Okay, a revocable living trust does not protect you from lawsuits. I wish it did. That'd be wonderful. Everybody in the world would have a revocable living trust, and then there'd be no more lawsuits. And that's probably the problem. It's just too easy. Because the issue with a revocable living trust, remember that you control it, right? You're the trustee. You also get to spend the money because you're the beneficiary. And so when you have that much control, the judge says, well, it's really still your money. And so if you get sued, it doesn't protect you from lawsuits. And so just something to keep in mind. There are other things we can do to protect you from lawsuits. And they're beyond the scope of this seminar, but just know we do that, and we can do asset protection and lawsuit protection. But this is the foundation of your plan, is the living trust, because everybody's going to die. But when it comes to protecting you from lawsuits, we need to do other stuff. And so, we do like LLCs and irrevocable trusts and family partnerships, things like that will protect you from lawsuits if you're in a high risk category. But I really wouldn't even worry about it if you're not in a high risk category. Like, for example, if you own rental properties, then yeah, we need to be concerned about lawsuits, because rental properties usually mean lawsuits. I could tell you all sorts of horror stories about rental properties and lawsuits. Or if you own a business, or if you're a doctor, then we should probably do additional planning beyond the living trust to protect you from lawsuits. But other than that, I would just have a good insurance policy for your car and for your home. All right, let's get to mistake number 2, is letting your estate plan collect dust. All right, this is probably the most common one I see. It feels so good to get your trust done, and then you want to stick it on the shelf and never think about it again, right? So I would just like to encourage you again, because some of you may have a trust already. Our recommendation to clients, again, is every 3 years. Dust off the cobwebs, bring it into us. And for our clients, we review their trust for free every 3 years. That's just part of being a client, because we want to help them keep it up to date. And so, maybe there's been changes in the laws, and maybe there's been changes in your family. Maybe you need to change your beneficiaries, or your kids are older now. Maybe you want to get Uncle Bob off as the trustee and have one of your kids be the trustee now. There's all sorts of changes that might happen. And so if it's been too long, then be sure and have your trust reviewed. We, of course, be glad to review it as well. We can review your trust at no charge and make recommendations as well. But it's just that peace of mind of knowing that the trust is up to date. That's what I want at the end of the day, is not for you just to have a trust, but to have a trust that's actually going to work when the time comes. All right, well, let's get the drum roll here, okay, for mistake number 1. Mistake number 1 is I understand how important it is to take care of my estate plan, but I'm too, and then in that blank, you just fill in your excuse, okay? Whatever your excuse is, write that. I'm too busy, I'm too young, I'm too old, I'm too rich, I'm too poor, okay, whatever it might be. A lot of people think that estate planning, or that living trusts are only for the wealthy. And hopefully you've seen from this seminar, that's not true. If you have more than $75,000, we're talking about probate. So we do trusts for clients of all walks of life, for the very wealthy, for the very modest, and everything in between. And it's just so easy to put it on the back burner, isn't it? It's just that thing we want to avoid. We don't want to have those conversations with our spouse and decide who's going to be in charge of the kids or whatever it might be. But I got to tell you, it is so worth it. I think that the comment that I get more often than any other from our clients as they're walking out, having got the trust done, is, gosh, this feels so good. Well, why didn't I do it 10 years ago instead of worrying about it all this time? And that's what I love about what we do. We're just so blessed to be able to work with clients that they come because they want to be there. And the nice thing about being an estate planner is your clients are by nature unselfish people, because estate planning is an unselfish thing, isn't it? And just the fact that you're here, even getting educated on it, tells me that you're thinking about the people you love. You're not doing it for you, you're doing it for the people you love. You won't even be here when all this gets sorted out, right? So I think that's admirable. And so I just love to help clients with that. We truly do love what we do. And we take our job very seriously, because I know, it's not just documents. We've seen enough real life action to know that the way we do the documents, the way you plan out your estate plan, it really does make a difference in the lives of the people you love. And my hope is that this will be a blessing for them and not a curse. And so, that's, we're at the end of the formal presentation. Where do you go from here? My suggestion would be just take some action. Okay, it's great to get educated, and that's the first step, is get educated. And I hope you better understand now the difference between wills and trusts and why all trusts are not the same. I would recommend that you work with somebody who does this day in and day out. Don't work with just a general practitioner. Don't just get something off the internet. There's too much at stake here to try to take things into your own hands. And so meet with an attorney. We, of course, would love to be that attorney, but just know that we're here to help you in any way that we can. We offer free consultations, and I'm not much of a salesman. I just really want to educate you here. Just know that we're here to help you, and be glad to meet with you for a free consult. You can call our office or send us an email, whatever it might be. In fact, we also, I do this with every seminar. I do a lot of seminars throughout the year. I offer discounts to clients that attend one of our seminars, not to be gimmicky. It's because you've been educated now in what estate planning is. And so if you were to come into the office, we would offer you a $500 discount if you mentioned that you came to this seminar, because that saves us a lot of time, knowing that you've been pre-educated. So we can just dive right into it and start designing the plan for you in that free consultation. And then from there, you can decide whether or not to go forward. And so that's how we would work. But anyway, my main point is take some action, get it done, give yourself that peace of mind, and it'll be well worth it for you.